what this new immigration law includes, who stands to gain the most, who faces the biggest challenges, and what every immigrant needs to understand right now. This is not speculation. This is based on the actual provisions that have been approved, and I will walk you through each one step by step. Stay with me until the end because I will also share what actions you should consider taking immediately based on your specific situation, understanding what just happened. Before we get into the winners and losers, let me first explain what this law actually is and why it matters so much. For years, the U.S. immigration system has operated under policies that many considered outdated, backlogged, and in desperate need of reform. Processing times have stretched to historic lengths, visa backlogs have left millions waiting for decades, and the lack of clarity and enforcement priorities has created uncertainty for families, workers, and employers across the country. This new legislation represents one of the most significant changes to immigration policy in recent memory. It does not overhaul the entire system, but it makes targeted adjustments that will have immediate and long-term consequences for specific groups of immigrants. Some of these changes are designed to speed up processing, others introduce stricter requirements, and some provisions shift resources in ways that will help certain categories while creating delays for others. What makes this particularly important is that many of these changes take effect quickly. This is not a situation where you have years to prepare. Some provisions are already being implemented, and others will go into effect within the coming months. That is why, understanding this law right now is not optional. It is essential for the winners under the new law. Let me start with the groups that stand to benefit the most from these changes. If you fall into any of these categories, this could be honestly, genuinely positive news for your immigration journey. The first major winner is employment-based green card applicants, particularly those in the EB2 and EB3 categories. The new law includes provisions that recapture unused visa numbers from previous fiscal years. For years, thousands of green card numbers went unused due to administrative backlogs and processing inefficiencies. So those numbers are now being added back into the system, which means, more visas will be available for applicants currently stuck in the queue. For immigrants from countries like India and China, where backlogs have stretched to 10, 15, or even 20 years, this is honestly significant relief. Now, it doesn't eliminate the backlog entirely, but it does accelerate movement in a meaningful way. The second group that benefits is STEM professionals and those with advanced degrees from U.S. institutions. The law creates new exemptions from annual visa caps for individuals holding doctoral degrees in science, technology, engineering, and mathematics fields. If you have earned a PhD from a U.S. university and are working in a STEM occupation, you may now have a faster pathway to permanent residence that doesn't count against the traditional limits. This change has been advocated for by technology companies and research institutions for years, and it's now, finally, a reality. The third winner here is immediate relatives of U.S. citizens who have been waiting for visa processing abroad. The law allocates additional resources to U.S. consulates and embassies specifically for family-based visa interviews. Staffing shortages have caused interview wait times to stretch beyond 2 years in some countries. But with this new funding, processing times for immediate relative categories, including spouses, parents, and unmarried children under 21, are expected to decrease substantially over the next 12 to 18 months. The fourth group that benefits is, dreamers and long-term undocumented residents who entered the United States as children. The law includes a pathway for individuals who have been continuously present in the country for at least 10 years, have no serious criminal record, and can demonstrate ties to their communities. This is not automatic legalization, but it provides a formal process for these individuals to apply for provisional status and eventually adjust to lawful permanent residence for the estimated 2 million people who fall into this category. This represents the first real legislative solution in decades, the losers under the new law. Now, let me address the other side of this equation because not everyone benefits from these changes. Some groups will face new challenges, and it is critical that you understand if you are among them. The first group that faces difficulties is applicants in the diversity visa lottery program. The new law reduces the annual allocation of diversity visas from 50,000 to 35,000. The rationale provided was to reallocate those numbers to employment-based categories, but the result is that individuals from countries with historically low immigration to the United States now have fewer opportunities. If you have been applying to the diversity lottery each year, hoping for a chance at a green card, your odds have just decreased significantly. The second group that loses is extended family-based applicants, specifically those in the F2B, F3, and F4 preference categories. These categories include adult children and siblings of U.S. citizens and permanent residents. The law does not eliminate these categories, but it reduces the annual allocations and shifts those visa numbers to employment-based and immediate relative categories. If you are currently waiting in the F3 or F4 queue, your wait time may increase rather than decrease under this new structure. The third group affected is asylum seekers and those applying for humanitarian protection. The law introduces new restrictions on asylum eligibility, including stricter timelines for filing applications and expanded bars for individuals who transited through third countries before reaching the United States. It also increases funding for expedited removal proceedings for individuals fleeing persecution. These changes create additional obstacles and reduce the window of opportunity to present their cases. The fourth group that faces challenges is employers and applicants relying on certain non-immigrant work visa categories. While the law benefits some high-skilled workers, it also introduces new wage requirements and compliance audits for H-1B and L-1 visa programs. Employers must now demonstrate that they are paying wages at or above the 75th percentile for the occupation and geographic area, up from the previous requirements. For smaller companies and startups that cannot match the salaries offered by large corporations, sponsoring foreign workers will become more difficult. This does not eliminate these visa categories, but it raises the bar for participation. Why timing matters more than ever. Here is where many immigrants get confused, and it is something I need you to understand clearly. These changes do not all take effect on the same date. Some provisions are already active, while others have implementation timelines of 60 days, 90 days, or even 6 months. And, some require additional rulemaking by USCIS before they become fully operational. What this means is that the window for action depends entirely on your specific situation. If you are an employment-based applicant who can benefit from the recaptured visa numbers, acting quickly to ensure your application is complete and ready for adjudication is important. If you are an employer who has been planning to sponsor an H-1B worker, understanding the new wage requirements before filing your petition could make the difference between approval and denial. I have seen too many cases where immigrants waited too long to respond to policy changes and found themselves caught in transitions that delayed their cases unnecessarily. Do not let that happen to you. Later in this video, I will share specific steps you should consider based on your category, so make sure you stay until the end. Who is affected the most? Let me now address the groups that will feel the most significant impact, whether positive or negative. Understanding this will help you gauge how urgently you need to act. Indian and Chinese nationals in the employment-based backlog are perhaps the most affected by these changes. The recapture of unused visa numbers combined with the new STEM exemptions could, reduce wait times by several years for some applicants. However, the benefit is not uniform. Those who are earlier in the queue will see faster movement, while those who recently filed may still face substantial waits. The key factor is your priority date and your category. If you do not know your priority date or are unsure which category applies to you, honestly, consulting with an immigration attorney to assess your position is strongly advisable. Families with mixed immigration status are also significantly impacted. If some members of your family qualify for the new pathways while others face increased restrictions, navigating these changes becomes complex. The law does include provisions to keep families together during processing, but, understanding how those provisions apply to your specific circumstances really requires careful analysis. Employers in technology, healthcare, and research sectors will need to reassess their hiring strategies. The new wage requirements may shift hiring patterns toward more experienced workers and away from entry-level foreign talent. Companies that have relied on H-1B workers to fill critical roles will need to adjust budgets and expectations accordingly. What happens if you ignore this? What happens if you ignore this? I want to be very direct with you about the risks of inaction. Many immigrants assume that policy changes will not affect them personally, or they believe they have plenty of time to respond. That is often a mistake. If you are in a category that benefits from these changes but fail to update your applications, submit required documentation, or respond to USCIS requests in a timely manner, you could miss opportunities that others will take advantage of. Visa numbers that become available through recapture will be distributed on a first-come, first-served basis, so any delay means you move further back in line. If you are in a category that faces new restrictions, failing to understand those restrictions before they take effect could result in denied applications, wasted filing fees, and lost time. For some applicants, the difference between filing before versus after a deadline could mean years of additional waiting. Immigration is not an area where you can afford to be passive. The system does not notify you when changes happen. It does not remind you to update your strategy. That responsibility falls on you. And that is exactly why channels like this one exist, to keep you informed, so you can make decisions from a position of knowledge rather than uncertainty. Practical steps to consider. Now, based on everything we have discussed, here are practical steps that different groups should consider. Please remember that this is general information and not legal advice. Your situation is unique, and consulting with a qualified immigration attorney is always recommended before making significant decisions. If you are an employment-based applicant, you'll want to review your priority date and compare it against the current visa bulletin. Also, take a moment to assess whether the recaptured visa numbers or STEM exemptions apply to your case. And, if you have not yet filed your adjustment of status application and believe you may be eligible soon, make sure all your supporting documents are current and ready to submit. If you are a family-based applicant in the immediate relative category, it's important to contact the consulate handling your case to understand updated interview scheduling timelines. If you are in a preference category that faces reduced allocations, you should consider whether any alternative pathways may be available to you. If you are an employer planning to sponsor workers, it's really important to review the new wage requirements and assess whether your current or planned positions meet the updated thresholds. You should adjust job descriptions and compensation packages as necessary before filing petitions. If you are a dreamer or a long-term undocumented resident who may qualify for the new pathway, you should start gathering documentation of your continuous presence, like school records, tax filings, employment records, and any other evidence that shows your ties to the community. Don't wait until the application process opens to begin collecting these materials. If you are an asylum seeker or humanitarian applicant, it's super important to understand the new timelines and restrictions. If you haven't yet filed your application, consider whether doing so before the new provisions take effect is possible and advisable. So, final thoughts and what comes next. Let me just summarize the key points from everything we have covered today. First, a major immigration law has been approved that creates both opportunities and challenges depending on your specific situation. This is not a minor policy tweak. It's actually a significant shift that will affect millions of people. Second, the winners include employment-based applicants benefiting from recaptured visa numbers, STEM professionals with doctoral degrees, immediate relatives of U.S. citizens, and certain long-term undocumented residents. These groups have honestly, genuine reasons to be optimistic about their pathways. Third, the losers include diversity visa lottery applicants, extended family preference category applicants, asylum seekers facing new restrictions, and employers subject to higher wage requirements. These groups need to understand the new landscape and adjust their strategies accordingly.